All right, Wednesday, July the 15th, the year 2020, part 9 of 10. They Got Their Man by Elmer Lynn Williams, a story of income tax persecutions. We're going to pick up at the top of page 161. I have been doing a grave injustice to an innocent man. The slowness of truth in overtaking falsehood is emphasized by Mr. Ike's statement that he had believed Mr. Bollinger guilty, even though 20 years ago, Mr. Franklin K. Lane, Secretary of the Interior, under Woodrow Wilson, completely exonerated Mr. Bollinger of all blame. Mr. Ike's quotes Secretary Lane as follows: "Like some others, I came here with somewhat of a prejudice against Secretary Bollinger. The results of my survey, however, have been a revelation to me. I find that Secretary Bollinger in his administration did the very best things that I had hoped to do and had established a highly efficient organization. I can find nothing to improve. He exhibited rare judgment of men in selecting subordinate executives. If, when I leave the department, there remains behind me that fine sense of loyalty, devotion, and affection that exists throughout the department towards Judge Bollinger, I shall feel abundantly rewarded. I have gone through this department with a fine-tooth comb and have analyzed with care every act of his when he was Secretary of the Interior, and I find every one of them meeting all tests of patriotism, service to the public, and the preservation of national interest." Mr. Ikes also quotes from a letter written to Mr. Bollinger by Mr. Alexander Vogelsang, First Assistant Secretary of the Interior in Wilson's administration. On March the 15th, 1921, Vogelsang wrote to Bollinger confessing that, like Secretary Lane, he started out with a prejudice against him. "Before my retirement," Vogelsang concluded, "I feel it due to myself to say that my experience here and the study and investigation I have made convince me that my impressions and my opinion were entirely wrong and unjust to you, and that I now believe that you were an able administrator and as honest in impulse and action as any man who has ever held the office of Secretary of the Interior, and that in the history of the Republic the high water of cruelty and injustice to a public officer was reached in the treatment accorded to you." How unfortunate that Vogelsang letter reached Bollinger in time to comfort. How fortunate that Vogelsang's letter reached Bollinger in time to comfort him. He died the next year. Yet again, I find encouragement in the Ikes article. If Mr. Bollinger can be referred to as an American Dreyfus, by how much more great propriety may that term be applied to Mr. Malone. Mr. Bollinger was never indicted by the testimony of perjurers. He was not prosecuted by an Iago who employed falsehood, innuendo, and appealed to prejudice before a jury of plain men confused and overawed by the government's machinery of prosecution. Mr. Bollinger did not sit before a judge who would not apply the rule of law in Malone's case, which he had employed to discharge a previous defendant charged with a more serious offense. Mr. Bollinger did not even lose his position and sacrificed only part of his private fortune. President Taft stood by Mr. Bollinger against public clamor and advice of friends. Mr. Bollinger's health did suffer under the bitter prosecution, which led to his resignation, but he did not need to lie in prison enduring both physical and mental torture. On the other hand, both Bollinger and Malone suffered some things in common. False statements given to the press deprived both men of a fair chance of vindication. Personal animus, devouring ambitions, conniving schemes, to use the language of Mr. Ikes, gave neither man a fighting chance. Apparently, there was nothing to which the Brake-Bollinger cabal would not stoop, says Mr. Ikes, and cites a secret meeting of the enemies of Bollinger in a private home in Washington during the investigation. Let the reader turn back to the men who met in the home of Mayor Edward J. Kelly while Malone's fate was not yet fully sealed. The group, as we have said, included Judge J. Earl Major, who wrote the opinion for the U.S. Circuit Court of Appeals denying justice to Malone. In the group was Iago, the Kelly Nash candidate for the U.S. Senate. In that group was Attorney General Cummings, Iago's superior, who later secured Iago a place on the federal bench. Cummings is now attorney for two of Igoe's former assistants, Glasser and Kretsky, in the U.S. Supreme Court. These men were convicted of graft and case fixing while Cummings was attorney general and when Igoe served under him as district attorney. Glasser and Kretsky were Igoe's assistants and were convicted in spite of Igoe's strenuous effort to defend them by testifying in their behalf, even going to the extent of assuming responsibility for all of their official acts. It is not necessary, after what has been recorded here, to remind the reader that apparently there was nothing to which the Break Malone cabal would not stoop. One more statement by Mr. Ickes is almost breathtaking in its similarity to the method employed to get Malone. Louis D. Brandeis, later a justice of the Supreme Court, was paid a fee of $25,000 by a magazine to present the case against Bollinger. It was really to an innocent technicality that Bollinger owed his crucifixion, says Mr. Ickes. Mr. Brandeis discovered it and used it to destroy Bollinger. But, says Mr. Ickes, there is no criticism of him, Brandeis, for making the most of it. After all, he was a lawyer representing a client, and he was having a tough enough time to convict Bollinger. This was the same alibi used by Michael Igoe as he stood before the United States Circuit Court of Appeals. Igoe justified his vicious attacks on Malone in the court below on the ground that he had difficulty in getting witnesses to testify against Malone. He was having a tough time trying to convict Malone and must needs be less circumspect than a prize fighter who, if he hits below the belt, is disqualified. Mr. Ickes' confession and penance and his portrait of Richard A. Bollinger as an American Dreyfus dispels any doubt of the right and propriety of giving that appellation to William H. Malone. Chapter 20, Recapitulation. Let us recapitulate the facts in this amazing case. William H. Malone and the local Internal Revenue Department disagreed over the amount of income tax he should have paid. The department demanded that Malone pay over $58,000 for the year 1929 and $1,010 for the year 1930. Government agents contended that this increase was the result of unreported taxable income. The entire amount was predicated solely upon the increase shown in his bank deposits. The burden to show proof of taxable income rested entirely with the government, and no taxable income whatever was shown beyond what Malone himself had reported. The government agents admit that he concealed nothing, that all of his books and records were available to them. When the government notified him that his tax assessments had been increased manyfold, Malone filed a protest, as was his right. The protest was based upon the fact that the deposits were not created by money and was not taxable income. Let me read that again. The protest was based upon the fact that the deposits were not created by money that was taxable income. That he knew could prove by competent witnesses when his case would be heard before the United States Board of Tax Appeals. Malone attached a letter to his tax return in 1930 calling attention to the fact that his books were being audited by the government for the purpose of settling the dispute, showing his willingness to adjust the claim in the event that he or the government was mistaken. The department head in Washington on 2 different occasions informed Malone and his attorney that no action would be taken by the government until he had... I got to interject a quick commentary before we go to 166. What the hell is the government doing looking at Malone's bank deposits anyway? Even if he did have a big bank deposit, how does the government know about that, and why do they get to use that against him? I thought that was like illegal. But anyway, that no action would be taken by the government until he had been given an opportunity to present his case to the Board of Tax Appeals, and also that the hearing could not be heard for a long time due to a great number of cases ahead. He was also told on 2 occasions that there was no criminal element in his case. During his second visit to Germany, the government totally ignored its promise. He was indicted on a charge of willfully evading his income tax. The indictment was based upon the testimony of 3 lawyers, 2 of whom represented the Pullman Company and the other the Chicago streetcar lines. These lawyers testified they had made campaign contributions to Malone, and the government claimed that he had not acknowledged the receipt of this money in his income tax report. He emphatically stated no such donations were ever made to him. These same lawyers had on many occasions tried in vain to persuade Malone while he was chairman of the State Tax Commission to lower the assessments on the capital stock of the corporations they represented. When he refused, they appealed to judges on the Circuit Court and Superior Courts of Cook County and secured enormous reductions of total cancellations of the taxes based upon Malone's assessments. They were paid huge fees for obtaining court order of these tax reductions, which Malone had denied them, and the government claimed that part of their fees was given to Malone. These facts stirred the author, and I believe will shock any unbiased mind. Expedience called for Malone to say, "Yes, I received the gift, but political gifts are not taxable as income and need not be reported." That would have ended the controversy in his favor, inasmuch as the donation had been made. He would not resort to moral cowardice and commit perjury even to save himself, and so the prosecution continued. Seldom have circumstances so combined to defeat the fair trial and equal protection of the law, which is so justly the pride of the English-speaking peoples. I got to read that sentence again just to make sure I don't vomit. Seldom have circumstances so combined to defeat that fair trial and equal protection of the law, which is so justly the pride of the English-speaking peoples. Excuse me and let me take just a small break while I go puke in my trash can. I certainly don't believe that is a true statement. Seldom have the circumstances. It happens every single day. Maybe they were surprised back in 1930, but in the year 2020, it goes on every day in every courtroom across this land. Though promised a civil hearing before his case would be sent to the Department of Justice, the promise was broken and he was indicted while abroad. To procure the indictment, witnesses were badgered into changing their sworn testimony under threat of imprisonment, and one witness was actually sentenced because he had the fortitude to refuse to alter his testimony. He was later, however, found innocent and exonerated by the U.S. Court of Appeals. Though not extraditable, Malone voluntarily returned for trial. To uphold the indictment against him and defeat his plea to have the indictment quashed, Judge Hawley, whom the case had been regularly assigned, and notwithstanding the fact that he had just sustained a similar plea based on the identical point of law in a previous case, referred Malone's plea to another judge. That judge overruled Malone's plea, thus helped Hawley sustain the indictment, and then returned the case to Judge Hawley for trial. The court struck from the record evidence which completely exonerated him of the accusation of having fabricated his defense after the trial started. To wrangle a verdict of guilty from the jury, one prosecutor in the closing argument, which with no supporting evidence and in the teeth of uncontradicted testimony that he had given everything he possessed but his soul to protect the depositors in two banks, painted Malone as a miserable wretch who loved nothing but money, who had sold his soul for its acquisition, who was a perjurer who had lied about his friends and lied about his associates. Every word he said was nothing but a lie, and you could see it on his craven face, that he was not a human being, but just a thing of clay, while the other prosecutor tearfully simulating friendship, claimed personal knowledge that Malone was untruthful. During the hearing upon the petition for a new trial, District Attorney Ego frankly stated to the court that if the Malone really possessed the currency in question before the year 1929 as claimed, then the government had no case against him. However, the district attorney added he did not believe it. Malone had sworn that he received the money in 1920 as a political gift, and his testimony in regard to that fact was corroborated by an unimpeached witness and has been supplemented by sworn affidavits of other persons, all of whom bear splendid reputations. The government, on the other hand, did not produce one witness in an effort to disprove Malone's testimony. Capping the climax, the court gave an improvident instruction so effectively sweeping away his entire defense that Malone, though for 15 years occupying with unblemished and spotless reputation and without a breath of scandal one of the most important public offices in this state, and for 30 years an honored, loved, and respected citizen among the people, among the people with whom he lived and he knew.
I didn't know it was that. Maybe it was like an hour.
There's very funny things going on in the background, and ask me about it later. Loved and respected citizen among the people with whom he lived and who knew him intimately, was convicted on literally no evidence. This case has created a paradox with far-reaching reactions and consequences. First, as I have pointed out, Malone could not legally be required to disclose the source of his currency. His agreement with Colonel Proctor not to do so Not to do so was legal and proper. The burden of proof, if he had failed to report taxable income, rested entirely upon the government, and it utterly failed to prove the charge. We are to ask to disbelieve sworn, corroborated, unimpeached evidence, and we are further asked to believe corporation lawyers when they testify that they made a political contributions to Malone when he denied receiving, and if received, would not be taxable as income. The vicious and indecent treatment accorded these American citizens when they arrived in New York was such as is not inflicted upon the worst criminals. Verily, I have never encountered such a brazen distortion of the legal rights of a citizen in all my 30 years of investigation into the political skullduggery so rampant and protected in Chicago. Here, then, I have related a shameful federal prosecution ending in prison sentence, the deplorable resultant disgrace and misery, including physical and financial ruin, all heaped upon an honored and beloved citizen of a democracy at a time when democracy itself is fighting for its very existence, while its defenders herald to the world that only through our system of government can life, liberty, and pursuit of happiness be preserved. Something has happened to the dignity, poise, and even-handed justice in our land. Has the Department of Justice been prostituted to the service of factional politics, to promote the ambitions of unscrupulous men, to destroy the reputations of honorable citizens, and to protect those who are manifestly guilty? I've got to read that paragraph again. Man, that's a big old amen right there. Something has happened to the dignity, poise, and even-handed justice in our land. Has the Department of Justice been prostituted to the service of factional politics, to promote the ambitions of unscrupulous men, to destroy the reputations of honorable citizens, and to protect those who are manifestly guilty? Wow. I'm going to say yes to that, and I'm going to say the fact that he wrote that in a book that was written back in the 1930s is absolutely foretelling of how bad we are now. In the opening chapter, the reader was urged to suspend judgment until the evidence submitted here had been carefully considered. Now that my task is ended, I am confident that those who have read will agree that definite, clear, and convincing evidence has been uncovered to establish the truth of my charge, that the indictment, trial, and conviction and prison sentence of William H. Malone constituted a shameful miscarriage of justice. Is there nothing left for such a victim but to grovel and pay to avoid total destruction? Shall we accept as true the poet's charge, wrong rules the land and waiting justice sleeps? Can anything now be done to right such a grievous wrong and obtain belated justice? Perhaps the statement of George Eliot in Romola is the only answer to the puzzle. Who shall put their finger on the work of justice and say, it is there? Justice is like the kingdom of God. It is not without us as a fact. It is within us as a great yearning. Because tyrants ruled in Christ's time, justice could not be had. Hence the following admonition in the Sermon on the Mount. When tyrants rule, agree with thine adversary quickly, whilst thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Verily I say unto thee, thou shalt by no means come out thence till thou hast paid the uttermost farthing. Wow. Even Christ knew how bad the court systems were, and he was saying, don't go into the court systems. Malone failed to adhere to that warning, so he was delivered to the judge, who in turn delivered him to the officer, who cast him into the prison, and his uttermost farthing was taken in the process. He who has been storm-tossed through long, dark hours at sea now finds his last hope to be the President and the Congress of these United States. The brilliant beacon of that harbor is in their keeping. May its light never grow dim. All right, we got to get to page 180 one way or another. All right, let's start on the top of page 171, and you know what? Let's do that on another time, and I will append it to this. Top of page 171. Appendix, Chapter 1. Birds of a Feather. The men we honor and the maxims we lay down in measuring our favorites show the level and morals of the time. Wendell Phillips. Muck raking. When there is muck to be raked, it must be raked, and the public must know of it, that it may mete out justice. Publicity is a great purifier, because it sets in motion the forces of public opinion, which controls the courses of the nation. Charles Evans Hughes, former Chief Justice, United States Supreme Court. With that truism in mind, let us now examine the records of the members of the Chicago political machine who, with consummate cunning, emasculate our courts, defy the electorate, filch our taxes, and reap the riches of a Midas. In the chapter describing the Sun American trial, reference has been made to the foul blows struck by Ego and his aide. These vituperative attacks upon a defendant in the presence of a jury by a United States District Attorney naturally raises the question, with whom had Prosecutor Ego been associated in the past that he should now recoil from the conduct and character of William H. Malone? What type of men has he delighted to honor? How noble must a defendant have been to enlist Ego as a character witness? Ego testifies. Several examples might be cited. First, observe Ego in the role of character witness. Excuse me. Thank God I'm not in public. If you sneeze in the pandemic, you get a $500 fine, I think. First, observe Ego in the role of character witness for George Remus, a Chicago lawyer and bootlegger. Remus, according to the press reports, made from $7 million to $10 million in the racket. October 12, 1923, the United States Circuit Court of Appeals confirmed a conviction of Remus and his associates, who were fined $121,000 and given sentences aggregating 29 years. Remus murdered his wife, Imogen, by shooting her in the head while she was seated in the park in Cincinnati, October the 6th, 1927. It was for this crime he was on trial when Michael Ego journeyed from Chicago to Cincinnati to vouch for the good character of Remus. Here is a report of Ego's testimony as published in the press December 9th, 1927. Prosecutor Carl Basler examined Mr. Ego in the Cincinnati court. Ego took the stand in a belligerent mood, told the court he was South Park commissioner in Chicago, had been assistant district attorney for years, a member of the legislature, and for 6 years, Democratic leader of the House. Ego got the same question as a previous witness on cross-examination, and in view of the fact that he, Remus, was convicted in Cincinnati and indicted in Chicago, do you still consider his reputation for peace and quiet, for truth and veracity as a man and a lawyer good? Basler asked. Ego looked straight at the questioner and said distinctly, "Yes, I consider it good." Mr. Ego told the court on cross-examination that he had represented Remus in the latter's trial. "Will you tell this court and jury what your fee was?" Basler asked. Remus rose to make an objection, but Ego raised his hand. Don't, Ego said. "I'm glad to tell about my fee. I understand Mr. Taft, son of a former President Taft, has been making some speeches around here about my fees. Well, I got more than $5,000 for my work for George Remus in that trial. He has shown a lot of canceled checks and identified them as payments to him from Remus." "Do you know John P. Alexander?" Basler asked. "No, I do not," Ego replied. "Do you mean to tell this court and jury that you don't know that John P. Alexander was none other than Remus?" "I mean to tell this court and jury exactly that." Question: "You got paid by Remus in checks signed John P. Alexander, did you not?" Answer: "Yes, I did." Question: "And you still say I don't know who he was?" Answer: "Yes, I still do not know who he was." "Ever get any presents?" "Yes, a fine suit of clothes once and a very fine traveling bag another time." "And that is all?" "Yes, that is all." Basler handed Mr. Ego a canceled check. "What about this check for $250? Didn't he give you that, as it states on it, for your campaign fund?" Ego inspected it. "I guess that's right. He must have given it to me." "What campaign?" Well, that was in 1920. It was when I ran for state attorney of Cook County. Bassler now handed the witness a number of other checks. One was for $5,000. Some 6 others the witness identified totaled $9,000. Eagle became a candidate for United States Senator in 1938 primary and was rejected by the voters of the Democratic Party. After his defeat, he was appointed federal judge. A new district attorney had taken his place. On September 29, 1939, a federal grand jury returned indictments against 2 of his former assistant district attorneys, Daniel B. Glasser and Norton I. Kretsky. They were accused of 50 overt acts, including conspiracy to defraud the government and bribery while serving under Ego. The prosecutors declared that there was an unholy alliance in the United States courthouse when Ego, Glasser, and Kritsky were in office. More than 100 witnesses appeared in the case, and 228 exhibits were turned over to the jurors. In an effort to save his pals, Ego stepped down from his exalted position on the federal bench, left his own courtroom, and volunteered as a witness. He vouched for the defendant's good character and conduct while they served as his assistants. He declared that he personally decided what was to be done about all the cases where the district attorney's office was involved, holding 2 conferences daily for that purpose. Notwithstanding Ego's testimony, Glasser and Kretsky were convicted. Their conviction has been upheld by the United States Court of Appeals and is now pending before the U.S. Supreme Court, where Homer Cummings, former U.S. Attorney General, is their counsel. It was while Glasser and Kretsky were serving as assistants to Cummings and Ego that the crimes for which they have been convicted were committed. Chapter 2. Ego pays reverence to Jim Colosimo, king of the Chicago's underworld. Let us now turn to a more colorful character whose sudden end evoked profound expressions of sorrow in Chicago's Vice District. Big Jim Colosimo came to Chicago from Italy about the beginning of the century, 17 and penniless. Michael Kenna Hinky Dink and Bathhouse John Coughlin, alderman of the First Ward, put Big Jim in charge of a gang of street sweepers, and he organized them into a political bloc. Colismo married Victoria Moresco, who gave him his real start. She ran a disorderly house at Armour Avenue and 21st Street. Colisimo took charge of his wife's brothel and collected tribute, made possible by his political backing, from other disorderly houses. He was master of the old levee district. His principal interests were syndicated vice, syndicated prostitution, and syndicated gambling. In the fetid atmosphere, such characters as Ike Bloom, Mikey Fritzl, Dennis Cooney, Johnny Torrio, and Al Capone also flourished. The politicians on the near South Side marked Colisimo for their own. Smart Fagans and, like Big Jim, were useful in herding the new voters at election time, controlling the count of ballots, and in keeping the political machine well-oiled with easy money from the underworld. They sought his favor, and after a time, Colisimo was telling them instead of asking them. Colisimo garnered a large fortune. Brilliant stones studded his garters and suspenders. This wealth and power brought demands from black handers. Sinister threats appeared in Big Jim's mail. Colisimo went to New York and returned, bringing with him 2 young graduates from the 5 Points gang of that city, Capone and Frankie Yale. Capone came to assist Johnny Torrio in guarding Colisimo. Yale would leave as soon as he had blotted out little Jimmy. Cosimano, who had telephoned Big Jim Colisimo, saying, "I am going to kill you someday. I don't know just when it will be, but it will come. Goodbye." Let us digress for a moment to allow a current writer describe what happened to little Jimmy when Frankie Yale undertook his assignment. A few days later, a big automobile whirled around a corner at high speed. On the corner, little Jimmy was foolishly enough taking some air. There was a terrific roar, and little Jimmy fell to the cement, his body full of lead. Writhing in pain, he was taken to the hospital by the police, who camped outside his door, intending to grab him if death didn't. And death didn't, but neither did the cops. Little Jimmy was a Sicilian, and he had many Sicilian friends who thought well of his talents and were distressed that the law might store him away. In desperation, they took the matter up with one Big Tim Murphy, a powerful underworld character since murdered. "What can we do for little Jimmy?" implored the agitated Sicilians. Murphy was silent for several minutes, thinking. Then he said curtly and without a smile, "Go up and take him." And they did. Our subject, however, is not Little Jim, but Big Jim, who for 20 years, through his powerful backing by the political machine, ruled the underworld. But now he made a fatal mistake. Miss Dale Winter, a musical comedy star, accepted employment in Big Jim Calissimo's cabaret. As this beautiful woman stood up nightly to sing to panderers, dope peddlers, bootleggers, thugs, and hoodlums, Big Jim began to feel more than a business interest for her. He bedecked her with costly diamonds and other precious stones. Miss Calissimo, jealous of his intentions to this songbird, divorced Big Jim in February 1920. Calissimo and Dale Winter went to Indiana and were married in the April of that year, but this newfound happiness was short-lived. The following May 11th at 4:25 in the afternoon, someone stepped softly behind Big Jim in his nightclub and shot him to death with a bullet in the back of his head. And now the political overlords descended to the underworld to pay tribute to the dead from whom they had received tribute when he was alive. In the maze of flowers surrounding the coffin was a huge clock built of roses, sweet peas, which had been presented by the First Ward Democratic Club. The hands of the clock pointed to 4:25, the hour of Big Jim's death. Chicago's Post, May the 16th, 1920. Here is a quotation from an editorial in a Chicago paper. Following the body of Big Jim Calissimo to the grave today will move a cortege which should interrupt the complacent thought of Chicago. A cavalcade such as moved behind the funeral car of Caesar is to pay homage to the memory of the man who far more than a decade had been recognized as the overlord of Chicago's underworld. Such tribute from men set up to make and enforce our laws, to man who in much of his life was a law unto himself, is more than the tribute of friendship. It is a tribute to power, regardless of the source or justice of that power. Jim Calissimo ruled in his world. Out of his rule came sudden death to him. Raised to the throne of the half-world, he was a maker and a breaker of political aspirations. His methods were ruthless, considering the law only insofar as to avoid its penalties. It is a strange commentary upon our system of law and justice. How far can power derived from the life of the underworld influence institutions of law and order? There also appeared in the Chicago Press another editorial entitled, "Our Laws Against Crime, Are They Adequate?" Whatever the motive of the murderer of Big Jim Calissimo, the crime further advertises the fact that there is a considerable region hereabouts where law is not. Or rather, there is law, but it is not the law of the land enacted by legislatures and applied by courts. The law this region knows is the law of the jungle. The underworld is part of our politics. Its influence is felt in the election of men who make our laws, of men who execute them, of men who interpret them. It is a reservoir of political and social disease and has much to do with our misgovernment. Behind the costly funeral car that bore the king of the underworld to his tomb, the following distinguished cortege of notables walked with solemn tread as honorary pallbearers: Mike Hinkydink Kenna, Francis Borelli, Saul Von Prague, former gambling housekeeper, Ike Bloom, owner of Freeburg's Midnight Frolics, George Silver, owner of the Friars Nightclub Cafe, Antonio D. Andrea, Democratic committeeman from the 19th Ward, Mike Potson, partner of Calissimo, now owner of Calissimo's Nightclub, Harry Romaine, well-known gambler, Eddie Ballard, owner of a notorious gambling resort, Mike Rosenberg, Democratic leader from the 19th Ward, also later sanitary district trustee, while Mayor Kelly was chief engineer. Mo, Mike's brother, gave $500,000 to politicians from money derived from the handling of Insult Utilities junk. Johnny Torrio, gunman from 5 Points, New York. Mike Merlo, Calissimo's partner and later head of the Black Hand Society. Michael L. Ego, Democratic leader in the legislature, later United States District Attorney, and now a federal judge. Verily, men are judged by the company they keep. The law of the jungle is a fitting phrase. Ego marched with head bowed in homage to the fallen king of Chicago's underworld. During all these years, William H. Malone was living a quiet home life in Park Ridge, where he resided over a quarter of a century. Chapter 3, Edward Joseph Kelly. All that I have, what little I have, I got from the good people of Chicago, Kelly. In August 1933, the Chicago Herald and Examiner began publishing articles concerning a mysterious high Chicago public official who failed to report to the government an income of $456,000. Mayor Kelly was asked if he were the official involved. He replied, "Any answer would put me on the spot." On August 17th, 1933, the Herald and Examiner named Kelly as the high Chicago public official referred to and stated that he made a compromise settlement with the government. Kelly had made returns for the years in question, but had not reported the $456,000 income. Senator Burton K. Wheeler, Montana Democrat, felt the disgrace upon the party by Kelly's conduct. He wired a warning to Washington protesting against entrusting federal funds to be expended by Kelly. In his telegram to Secretary Ikes, Senator Wheeler said, "If the facts as presented to me are correct, I feel that a thorough investigation should be made of the matter before any monies are turned over to these people, and I feel sure you would concur in this view." The Chicago Examiner commented on the Wheeler telegram as follows: "Wheeler's intervention is expected to bring to head rumors that the national administration has been reluctant to authorize public works in Chicago because President Roosevelt and his advisors did not want to entrust the spending of federal funds to the city, South Parks, schools, and sanitary district administrations. At length came a generous gesture of confidence in the form of $18 million for a subway. The same gang is now glutting itself with fat contracts, and Kelly's assistant engineers from the sanitary district during the Whoopi era are in command. Already the estimated costs are increased many millions, and the end is not yet. A new scandal is brewing." We'll pick up at the top of page 181 when we begin with the last part.